Okay. Oh, so I will be talking about predicted court decisions mostly. Today, however, I will mostly focus on the data and on the task rather than methods today. I will still describe the experiments that we've done so far with the European Court of Human Rights, so we all understand a little bit how prediction works, but in general, this is more about previous research and where it falls in terms of automatic prediction. So to give credit where credit is due, this work is not done just by me. So it's a small but interdisciplinary group that we've got. Michel is a lawyer, and he just got an ERC grant. So we're going to have quite a few colleagues both from AI and law joining us soon. Martijn is a computational linguist. I think he's in the audience. Xiao has been helping us a lot. He's also a computational linguist, and I've been stuck somewhere in between in the last 3.5 years. But I am myself also, by education, is a computational linguist, and computational linguistics is what I do to law, more or less. So I assume that you here or you are in this field because you've seen a lot about predicting court decision, and like a lot. And this is happening in the industry, but it's also happening in academia. So I'll have two main messages today. The first one is more for maybe the lawyers. Is when you see all these papers and see all this media, don't really trust the hype. And the message for the AI professionals or computer scientists is look at your data very carefully when you work with legal data. So when I talk about research and predicted court decision, I will be specifically talking about the ones that use natural language processing. It's not always the case. This is just to narrow the scope, but there's two honorable mentions of the papers that use manually annotated data, but they don't use any text. These both predict decisions for the Supreme Court of the Supreme Court of the United States. And Sharma is improving on the results of earlier version of this CATS paper. So basically they use the information about from the Court of Appeal to predict decisions of the Supreme Court, but they don't use any text. So I'm not going to be talking about that much. So really, this exploded in the last 5 years. All started with Aletra's paper that our discussion already mentioned a little bit. So this is the paper on predicting a decision of the European Court of Human Rights for 3 articles of the convention. And once that happened, quite a few papers came out next year for a variety of courts, then a bit of a low year, then a lot more and a lot more. So I will also assume that maybe I missed some papers that might come out in December and November in 2020, but this really has been a year for predicting court decisions. So we had a paper in 2019, it got a volume in 2020, so it's here. And also one paper for predicting also European Court of Human Rights cases in this year. So it looks like a lot, but first of all, let's notice that most of them are predicted decisions of the European Court of Human Rights. So everything in green is just one court, specifically all in English except for one paper. And I put this paper called Net in here. They don't directly say that they do predicting court decisions. They say they're identifying, detecting the outcome in the court decision, but they compare their results to the papers that say they predict court decisions. So I'll keep it there. for now, and we'll discuss later how maybe they're right in doing so, actually. So this is what we've got. So now I'm going to briefly talk about how we did predicting court decisions in our first paper. So specifically this paper, I'll just quickly go over algorithm is in some simple terms, so we're all on the same page in how it works. It's quite a simple model that we present here. It doesn't necessarily mean that it's bad, but there are a lot of different methodologies and ways to represent data and so on that can be used. But in essence, they all work sort of in the same way. So I'll just talk about this one. So again, so we're all on the same page. European Court of Human Rights, judges on the European Convention on Human Rights. Mostly it's an individual that is suing the state that they are resident in for violation of their rights. There's been 47 states that ratified the convention. So, each case can be judged by 3, 7, or 17 judges, depending on complexity of the case. So, in all honesty, predicting court decisions for the European Court of Human Rights is not very interesting. For the Supreme Court in the United States, it may be, because it affects so many people at once. I don't know, their right for abortion, right? That affects half of the population immediately, right? So, or the entire population, you can argue. So, but with the European Court of Human Rights, there might be multiple applicants per case. But mostly it affects individuals, and so really when you predict something, you predict it for this one person, and generally we cannot do that with high enough certainty for it to be, at least for now, to be interesting enough. What our goal in this paper was to see whether we can actually identify the predictors of the predictors rather than the prediction itself. So ideally, we would want to, let's say, okay, if this was the fourth section and these judges were on the court, this is just an example of one of the cases, and it was a drug-related offense and there was a fine and so on, that we can say with reasonable certainty that there was a violation of human rights, for instance, right? So for us, that is a lot more interesting, that we can find certain patterns and see what influence a certain decision rather than predicting the decision itself. So the way that we do it is we scrape the data from that is published by the European Court of Human Rights. They publish all of their cases online. Then we do some pre-processing, taking out the parts of the text that we want to use. Then we do some balancing, we train the model, and then we do the prediction. So this is what a court case looks like in abstract, but the majority of cases will have this structure. So there's information about the section, who the judges are, the registrar is, and so on, information about which cases, which country is involved, and so on, application numbers. Then there's procedure, which is the steps that the applicant took before they got to the European Court of Human Rights, all the domestic remedies that they took. Then there's the facts section, which summarizes the facts of the alleged violation. Then there's the law part, which is really the arguments of the court towards one decision or the other. Then there's a verdict per article of the convention, quite structured. And then there's dissented opinions when a judge disagrees with a majority decision. They can be not there. Okay, so this is the part that we use. In reality, we mostly use just the facts. The reason that we don't want to take the other parts specifically is, well, the verdict contains what we want to predict. And in reality, the law part also contains what we want to predict. So when the court talks about it talks about its decision, it mentions the decision quite clearly. So basically, we want to see specifically which facts will be the predictors of the violation, not which arguments. And again, we don't want to bias the data. So what we want to see is just, given the facts, can we guess what the violation is with a reasonable certainty? So next stage is balancing. We take all the cases. In the data set for this paper, we had a lot more cases of violation than with no violation. And the way that machine learning works, that very often if the classes, so violation, no violation, are really unbalanced, then the system may just learn to predict, for instance, always violation. It will get quite a high accuracy, but it will not mean anything. It will not actually learn anything. So what we did is anti-sampling. So we removed randomly the cases with violation so that we have the same amount. And then we applied an algorithm. In our case was SVM, which basically looks at, so the way that the whole system works is that it looks at words and phrases within the text and weighs them based on how characteristic they are of a certain class, violation or no violation. And then the algorithm basically tries to separate these classes linearly in the best possible way. So there are some algorithms that could go around here. But for this time, it's a baseline model. It already works pretty well. This is what we did. So once the model is trained, what we do is we take a new case, and again, the system looks at words and phrases within that text and sees whether the words there are more characteristic of the violation cases or no violation cases, and therefore takes an educated guess towards one decision or the other. So that's basically how machine learning works. There can be a lot more algorithms going around. You can do a lot of things with the unbalanced state and so on, but this is sort of the essence of it, at least for working with text. So in our paper, we did 3 experiments. We did just predicting decisions. We did predicting future decisions by training the model, all the decisions, and predicting on the newer ones. And we tried to see whether just using the names of the judges would be enough, right? So these are our results. We did it for 9 articles of the convention, but here is just the ones with the higher number of cases because the results then are more reliable. So we had a balanced test set as well, which means that if the model was just guessing, would be 50% accuracy. So 77 on average is quite good. Sometimes even 80 for some articles, right? But we also see that if we predict future decisions, then the accuracy drops quite drastically immediately, which is sort of explainable. Of course, so first of all, the interpretation of convention changes, even if convention doesn't change much, and also understanding of certain things. For instance, so Article 3 is prohibition of torture, and what was torture 30 years ago and what it is today are very different things, right? So it's understandable that predicting the future might be harder, but it also indicates that this is the task that we should orient on if we want to sort of be able to understand something about future decisions, right? So we also predicted decisions based on judges' surnames alone, and we also got some controversial results. I'll talk a little bit more about it in 2 slides. So again, here, we didn't want to just do the predictions. We wanted to see what the system chooses to predict it based on. So we can see, for instance, Article 3, prohibition of torture, there are some phrases that sort of make sense intuitively. Asylum seeker, conditions of detention, force used, and so on, that they indicators of violation. And there's some mostly rubbish in the non-violation part. So this is just, again, this was a really simple system. We didn't remove almost anything. So this is just sort of, if you give all of the words from the text to the system, this is what it decides. So, but while it might not, so some of these things are sort of reasonable, even if it's not always reasonable, this is sort of a way to move from. So you start with this, and then hopefully you can look at longer phrases or at sentences, facts even, and so on. So we did with the same with the judges, and this is, so basically for Article 6, these are the judges that indicate violation, these are the ones that indicate no violation. And this is where it's really important to say that this by no means means there's bias. It's for example, this graph can be explained by the fact that some countries are notorious violators of certain rights, for instance, Article 6, right? And then the judge from that country, appointed by that country, will have to be on all the cases from that, against that country. So there might be a lot of decisions by a group of judges towards violation, just because there has been a lot of violations in that country, right? So it doesn't necessarily mean that they vote in a certain way, it just might mean that they have a lot of cases like that. So there was a ban on predicting court decisions for French cases because of the not necessarily, the possibility of misinterpretation of these cases. So it's really important to check, to remember that correlation doesn't mean causation, basically. Okay, so I keep saying predicting, and I probably said the word predicting already 50 times, and I hope by the end of this lecture we'll all agree that I was wrong to do so. Basically, I keep saying predicting, but at the same time we use the final judgment of the court case, which we do not have in advance, and we predict the decision, right? So in reality, we're just sorting the documents in different groups, the ones that have violation, the ones that don't have violation. There's no, so it's not really a prediction of future decisions. If somebody with who is potentially had their rights violated comes to you, you cannot tell them, okay, tell me what happened, I'm gonna tell you whether you win it or not, because this information is structured, summarized by the court, that there's no real way to predict in the sort of a real life sense. So why do we keep calling it that? Why do every paper keeps calling it that? We had it in the paper, I think, 198 times, the word predicting. And the reason is that in terms of natural language processing or machine learning, this is indeed a prediction task. Because the way that the machine algorithm works is that you have the data that you fit with your labels, and then based on that data, you predict the label. So it is indeed prediction, but only in that machine learning sense. So what we decided to do, and this is the main reason I'm here, is to distinguish between different types of tasks that fall under predicting court decisions that we've seen in the paper so far. So one is identification, the other one is classification, and the other one is forecasting. So identification will be the task of identifying the outcome within the judgment. Classification, the task of determining the outcome on the basis of judgment that is known, but excluding the information that contains the outcome. And forecasting is actually determining the outcome before the outcome is known. So that could be based on some data that is available beforehand, which can be a composition of the court, if you know that. With Supreme Court in the United States, you might know it. Of course, with the European Court of Human Rights, and depending on the year sometimes. Or for instance, text of legal documents from some other documents. For instance, if you predict for the Supreme Court, you might use the text from Court of Appeal, so it's from the previous stage. So identification. I just want to, we already sort of decided on the definitions, but sort of look through a text. What a part of the text would we use to do that? Let's say we have the same X versus the Netherlands case and a more sort of general description of a case that might exist in a lot of courts. For instance, there's some sort of information about the court type, Court of Appeal, Supreme Court, lower court, the place, maybe judges, maybe all kinds of other information, maybe something about the procedure, especially if it's a higher court, some facts or statements by the parties or something like that, arguments of the court, or the summary of everything together, and if you like, a verdict in a structured way, and a lot of other information, of course. So basically for identification, what you want to find out, if you want to identify the verdict, is the verdict, right? But you never know what the structure of the cases are for different courts, so could be that you will use arguments of the court as well, maybe everything altogether, right? It is, why do we need this, right? It can actually be an extremely useful task. With the European Court of Human Rights, the verdicts gets published in the metadata with the cases. But for instance, we work with the eviction cases for the Dutch case law, and then we want to see, for instance, whether the eviction case resulted in eviction or not. And this is not such a trivial task at all. Alina, I think also in the audience, she presented recently at the UDEX conference. I believe she was identifying verdicts for the some US courts, and they had to use neural networks because it still didn't identify everything. So it can be quite a hard task. And in general, it can be useful by itself. Again, we want to find out how many eviction cases end up in actual evictions. It can become labels for certain data. For instance, in the same eviction cases, can we see what influences the decision? If children are involved, we can extract that information maybe, and then see, okay, if children are involved, the eviction usually doesn't happen, stuff like that. So then if we have the labels, we might actually use it for classification. So in terms of classification, we would, for instance, the way that we did it in our case is use the facts, so maybe procedure, maybe court information. Generally, so for the European Court of Human Rights, we could not use arguments of the court or verdict for obvious reasons, but sometimes you might be able to use arguments as well. For instance, if you want to see, sort of identify arguments, which arguments lead to a certain verdict, right? But then you really need to make sure that the verdict is not in there, or it's masked in some way, that your model doesn't just learn the verdict and then can predict it. So yeah, this is what we did for our. So in a lot of times, if you don't extract anything other than this prediction of the class from the classification task for court decisions, other than the outcome, it's not really useful. Because what we really are doing then is we're taking the court case and just stacking them into 2 stacks, one with violation, one with no violation, one with eviction, one with no eviction. And to be honest, that can very often be done much better without machine learning. It's a very complicated method to do this. Often with the European Court of Human Rights, you could just look up on the website and sort it by violation and no violation, right? Sometimes a simple keyword search will help, right? So it's, if the only thing you want to get is 2 stacks, this is way too complicated for that. So, and then we move on to forecasting, which is basically, we can't use the final judgments, but we can use something available before, submissions by the parties, facts of the pending cases. I'm going to mention it later for the European Court of Human Rights. We've got those, for instance, maybe judgment of the lower court, as I mentioned. And you might be able to use these cases maybe to get a verdict, or we, for instance, used the facts for training, but not for testing as well. So let's take all these papers that do predicting court decisions and try to sort them into these 3 categories. I mentioned before the COLNET that they already say they do an identification, and goes there. Then ALETRAS, inadvertently doing that. So as I mentioned before, we removed the law part because it contains the decision, the verdict in it. They did not, unfortunately, which means that they had the verdict inside the data when they were training it. So basically what they did was identification. Then all these papers use the same data set. So I don't think it was their intention, but this is what they ended up doing as well. QEMI, also European Court of Human Rights, they created a new data set, but also did not remove the law part. Tucho is Philippines paper. They specifically also say that they could not do that, even though they understand the issue, but they could not separate their verdict out. And Zulia, they didn't mask the verdict, but very specifically, so I'm not sure exactly where it lies between identification and classification, so I'll put it here. So already out of predicting court decisions, a big portion are actually just identifying what the verdict is. So again, I will, it's not necessarily a useless task, not at all, just for European Court of Human Rights. It's not entirely clear what it is for, because this information is available. From the methodological standpoint, maybe they can find something. But we also have to understand that then the scores, which is usually somewhere in the 70s, are not that great. So for the forecasting task, that would be quite high. But for identification, again, as I mentioned, I think it might be too complicated of a method to get to this result. These are the papers that fall under classification. So the true meaning of prediction, which is forecasting, is really not that many. Yeah, here I mentioned a few identification, 2 identification papers that show that it can be quite a complicated task and useful task. So these 2 papers, Brazilian papers, they don't mention separating the data. I believe maybe this is Thomas, maybe he can tell us otherwise whether they did it or not. Usually it looks like if the stage of pre-processing is not mentioned, then the law part or arguments of the court are included. So usually that means it belongs to identification. Moreover, I doubled the Chalkitas paper here, because one of their tasks is predicting whether there was a violation of any article of the Convention for the European Court of Human Rights. And the other task is predicting the article first, and then predicting whether there was a violation or not. The problem there is, again, first of all, the court publishes which articles are involved in each case, actually long before the case is judged. And moreover, this information is included in the text. So in the facts of the case, which they use for prediction, they will definitely be said that the applicant invokes Article 3 of the convention or whatever. So this is, again, they make their life a lot harder for, and I think the gain is too low. So out of the classification papers, only 4 really sort of at least try or indicate that this is important to sort of showcase what leads to prediction. So the rest, quite a few here use neural networks. So Chalkidis also uses a neural network that you can still look at how it makes the decision. But basically, these ones, in essence, sort the documents with violation, no violation, based on facts. But still, you can't really gain much from it from the legal standpoint. So this does not look as romantic as it did in the beginning of the talk, I think. So far, predicting court decisions is, in the real sense, is quite limited. So in reality, as far as I know, there's these 2 papers. So one is ours, and one on the German tax appeal court, I think. And the Katz-Harmer papers, but they did not use NLP, but in essence, this is also what they are doing. So it's not, again, here, it would be nice to sort of explore the methods for identifying verdicts and so on, but I don't think that these papers really do that. So here I'm going to talk very quickly about how we did forecasting, and since this is what I clear to be real predicted court decision, and let's start calling forecasting. So basically, the reason we were able to do that is that this is the process through which an applicant goes when they want to get a decision of the court. So first there's an application, then there is a formal admissibility where, for instance, the court requires that you apply within 6 months of the violation, of alleged violation. So if that didn't happen, the case will be thrown out on the spot and so on. So there's these kind of admissibility. Then there is a part called communication. It doesn't happen every time, but very often for the cases that will move forward. So basically, this is the court informing the state that it is being sued for an alleged violation. And what it does, it takes the application of the alleged victim, summarizes the facts. This happens years before the judgment is made. So it is true, we cannot take in an applicant and say, okay, I know whether you're gonna win the case or not. But still quite a few, so the length of this process can vary, but it can be 8 years, it can be 2 years. So it's still, we could do it really in advance. So the way that this communication looks is the summarization of the facts and some questions to the parties, which is to the state to corroborate on whatever happened. So it's usually quite short texts, but it's just the facts. And again, the court has not really looked at it yet. So then it goes through admissibility, which really clear non-violation cases also get thrown out, but in reality, because they evaluate on a merit, this is just clear non-violation cases. And the ones that do find to be admissible, move on to judgment, and then this is the final cases that we would get. So for the last paper about UNDERSAMPLING, it was also on the website, I think. What we added to the system is that, again, rather than only doing a prediction, wanted to do some analysis. So what we do is we highlight the sentences that are indicative of one prediction or the other. So we can actually, this is the website, undersams.com. So we can actually go. I hope you can still see it. Now the website. So we were did quite nice in December. So basically what this website does is every week it updates so twice a week the court publishes the cases, and we update it every week, I think. And then, so basically we have the decision of the court and the prediction. So the way that we've set it up now is that we want to sort of keep up with the court. So what we do is we retrain the model. We get the decisions every week, and then every month we retrain the system, and so that it would keep up with the court, and then we predict decisions for the next month. So actually we can predict decisions for all the pending cases, but we compare every month with the decisions that the court made. So here's, for instance, the decision of the court. Here's the prediction of URI. Let's have a look at a case. So you can see here the text of the case. The URI decided was violation with a 80% certainty. There was a data violation of at least one of these articles. We can see that the case was communicated 2 years in advance. So this is theoretically how long in advance we can predict these decisions. And we can see with different sentences with a certainty that it belongs to a certain class, so violation or no violation, and sort of the sum of these things go into the final algorithm to decide. So I was planning to about end here. So yeah, you can, the website undersams.com, I'll also put it in the chat, and everybody can go and play around. But I think I'll just move here to the contact.